Hello, and welcome to today's topic of how to close a company in Germany. I am Richard Hoffman, partner and lawyer at Ecovis International, and will guide you through today's episode. Companies in Germany may want to close their business for various reasons, such as changes in their business scope due to financial problems or failure to adapt to the market. Whatever the reason is for this decision to shut down the business, investors cannot simply abandon the company or stop trading and walk away without following proper closure procedures. It is not enough to simply start doing business or selling products when opening a business. There are different reasons to close a company. Most of the legally defined reasons for the liquidation of a German limited liability company are in the Companies Act. Some common reasons are shown above. The termination of a GmbH can also have reasons which are not expressly mentioned in the Limited Liability Companies Act. In a nutshell, there are two main manners in which companies are wound up: compulsory closure and voluntary closure. But today, we will primarily focus on the voluntary closure. The existence of a GmbH is inseparably bound up with its entry in the commercial register. Accordingly, a GmbH exists until it is deleted from the commercial register. The way to do this requires a certain procedure as well as a corresponding time schedule. To terminate a company in Germany, there are 3 steps involved: dissolution, liquidation, and deletion. The dissolution phase marks the beginning of the liquidation of a GmbH. Important. The legal personality and capacity to act of the limited liability company continue to exist until it is deleted from the commercial register. Only the purpose of the company changes during this phase. Instead of operating economically, the company is to be liquidated. If you would like to dissolve a GmbH on your own initiative, the first step is usually a corresponding resolution by the shareholders. The dissolution of the company must be submitted in a notarial certified form to be entered in the commercial register. Unless you have otherwise agreed in the Articles of Association, the resolution requires a majority of 3/4 of the votes cast. After the dissolution, the phase of the liquidation begins. The liquidator is responsible for the proper liquidation. Upon this announcement of the liquidation, the so-called waiting year begins. The waiting year serves to protect creditors, beginning on the day on which the notice to creditors is published. During this period, no assets of the GmbH in liquidation is allowed to be distributed to the shareholders. During this time, it is only permitted to settle claims of third parties. There is no ranking among the creditors. After the dissolution is registered and published in the commercial register, liquidators are obligated to inform all outstanding creditors about the need to file their claims. This notification initiates the waiting year, during which asset distribution to shareholders is prohibited. Additionally, liquidators assume the responsibilities that would typically fall on managing directors. This bookkeeping obligation includes preparing an opening balance with an explanation at the beginning of the liquidation, a final balance at its conclusion, and annual interim balance sheets for extended liquidation periods. After settling all liabilities, the liquidated company's assets are distributed to shareholders. A specially qualified auditor confirms that all creditors' claims are settled. The liquidator registers the end of the liquidation, signs it with a notary, and submits the final balance sheet to the court. Once the completion of liquidation is entered in the commercial register, the company is considered terminated. At Ecovis Richard Hoffman, our corporate lawyers will guide you through the closure proceedings and assure you that the closing of the company will be carried out in a proper legal manner. Our team of financial and tax professionals will oversee the financial side of the operation and prepare the financial statements, liquidation balances, and tax returns. Closing a company is associated with a large amount of organizational effort. Therefore, an experienced and qualified legal expert by your side is necessary to be able to analyze the lack of assets and to choose the appropriate procedure. Our summary is only a compact information. The winding up of a company must be clarified in each individual case. Our legal team can advise and accompany you through the whole process in German, English, or Chinese. We offer an initial consultation and performance review, and we will be happy to examine the prospects of successfully terminating your company. Thank you for watching and stay tuned for further updates.